got a really interesting one today. This is a topic I've often thought I might move towards later in my career. We're talking with Mark Duckett from Robson Forensic, a forensic expert witness company that helps us get to the root of the failures we see. From bridges in the news to poorly maintained handrails in your neighborhood, there are many issues that structural engineers have the best understanding of what went wrong. And more than just figuring out what happened, we can use that data to change how we practice in the future, making it better. At least that's why I love this idea. Let's talk in 10 years and see if it's part of what I do. We also accidentally say Robson Forensics a few times. It's just forensic, singular and adjective. We'll put their website in the show notes so it's easy to get to anyway. All right, let's have some fun.
The Structural Engineering Podcast.
Thank you for joining us on the Structural Engineering Podcast. Max and I are really appreciative that you took time out of your day to talk to us. I know for both of us, the topic of forensic engineering is very intriguing, and I think we both have an idea of what you do, but we're really excited to learn in more detail. Would you mind starting us off with just telling us about yourself a little bit?
Not at all. Thanks for having me on board. I'm excited to get the definition, I guess, is a good phrase of what we do as forensic engineers out to the structural guys out in the world, because guys and girls, because before I became a structural engineer, I was like most engineers, I was a consulting engineer. And I kind of had an idea that this industry existed, but my background is essentially as a consulting engineer. You know, I came up through the ranks here in South Florida, working for some big, stable consulting engineering firms, had the opportunity to get out in the field a lot, which is something that every structural engineer needs to do. Had the opportunity to work on a number of different types of projects, see them through construction in the slowdown around 2009, 2010. Sorry, before that, I forgot. I had left the consulting world working for other people at one point, went off, had my own business for about 15 years, solely consulting, working mostly for architects. And around 2009, 2010, I realized the phone wasn't ringing and picked it up just to see if it was still working, and it was. And decided I better find a job. And I looked in the want ads and found a job for a forensic structural engineer that, interestingly enough, had my exact skill set written down. Called them up, reached out to them. It was Robson Forensic. I worked 1 year for them as a consultant, part-time, and I've been there almost a little over 15 years now, almost 16 years.
That's wonderful. I like that their description fit exactly what you are used to doing. And in that, though, what part of the design field or your experience in there has been the most valuable in forensic work at this point?
Part of my time as a business owner, where you don't have anybody to ask, you have to do all the research, right? There's nobody to ask, what does this mean? What do I do here? So it required me to do a lot of research all the codes, research all the standards, research the ACI recommendations, the guidelines, go through the ANSI standards, go through all I actually bought, back when we bought things instead of bought them online, I bought books. I bought the ASTM standards. I've got 4 volumes sitting behind me there. And, it was a real learning experience. That and get out and get out in the field, see projects to the finality, go through the construction, go through the problems, work through the problems.
Yeah. For a lot of listeners that may not know Robson Forensics, what do you guys actually do?
We provide litigation support, right? So almost 100% of our work involves working for attorneys that are involved in some sort of litigation matter. In the few instances where we're not directly working for an attorney, we're possibly working for the insurance company in that litigation matter, or sometimes the homeowners or the owners of companies may hire us directly. But the whole thing here is, as a forensic engineer, we are needed to we need to explain complex technical issues to the trier of the fact, judge or jury. So by our education, training, and experience, we're able to take these very technical matters that you and I know, and all the listeners here know like the back of our hand, but you go to your neighbor and you start talking about stuff like that, and they look at you with glazed eyes. They don't know what you're talking about. When I first came on, I had twin daughters that were probably about 7 at the time, and I would make it a practice to tell them. And if I could explain it to them, I knew I could explain it to the jury, and they actually understood. After a while, now they don't want to hear anything about anything I do.
Gosh, in that respect, we've said the words the expert and standard of care sort of things. What does the word expert mean in this legal sense in the forensics world? Is that sort of a defined, specific, you have been an engineer for a certain amount of time, now you're an expert?
Yeah, that's a great question. I wish it was that easy so that it kept a lot of what people who call themselves experts or refer to themselves as experts technically aren't. So the definition of an expert is, like I said, you have to provide litigation support. You have to be able to tell a jury and explain technical issues. As far as in the real world, there's no real exact number of years you have to have as an experienced structural engineer. At Robson, we like to shoot for a minimum of 15 years. I guess the best way to explain what an expert is there's a thing called federal rules of evidence. So you can have a trial that's either in a state court or a federal court. They have rules of evidence or rules about expert testimony. As you would suspect, the federal rules are a little tighter. We try to adhere to the federal rules. And what they say is this is called Rule 702, testimony by an expert witness, which is ultimately our role, is to provide testimony, right? Either written in a report, verbal in a deposition, or verbal in a trial. So a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify if the expert's scientific, technical, or other specialized knowledge will help the trier of the fact understand the evidence or to determine a fact and issue, or the testimony is based on sufficient facts and data. That's important. The testimony is the product of reliable principles and methods. What I come up with through my scientific method analysis, another expert should be able to come up through taking those same steps and arrive at the same conclusions. And the last one, the experts reliably applied the principle and methods to the facts of the case. You can't make up facts, that help you. But those are the rules, and as long as you stay within those rules, you are identified as an expert in the case. If you don't, you can be thrown out. A common phrase is called Daubert. There's a ruling, a lot of cases, seminal cases, are referred to by a name. In this case, Daubert was one of the members of a I don't remember if he was the engineer or one of the attorneys, but an expert witness was first called out by not meeting all of those criteria. So they threw him out of the case. When you get thrown out of the case as an expert, your side has lost the opportunity to provide an expert. You can't go back and hire one then. It's like an automatic you lose. So a lot of attorneys now, Robson has been seeing a lot of what are called Daubert challenges, where the other side tries to get us kicked out for some technicality. We are very cognizant of this fact. I'm a peer reviewer. I'm the practice group leader for the structural engineering group at Robson. I'm also a peer reviewer, which means I peer review calculations and reports. All of us practice group leaders, all of us peer reviewers, one of our roles is to ensure that our work product, written or verbal, adheres to Rule 702 across the board. We need to be Daubert safe at all times.
Gosh. Wow. Most of my I don't know, in my mind, that like the court that I'm aware of, or I, it's from TV, right? I don't spend my time in
Sure.
court like you do. And that was going to be a question, was like, how often are they trying to say that you're not an expert? I mean, that is so surprising. I would have guessed that they could have hired another expert and just said, that one's, we don't agree with, but we could try a new one. So that's mind boggling.
So they have what they call, they have to disclose their expert. They have an expert disclosure date. It's a deadline. The courts, that's another thing that's very different in forensic world than in the consulting world that we all at one time, or you guys still do exist in, the time frames. So in consulting, you get the job, do the job, get paid for the job, move on. In forensic, you're at the mercy of not only the attorney's schedules, but more importantly, the court's schedules. And I have a case from 2022. I mean, that's not unheard of. I think actually I may have a 2020 case that's still ongoing.
Wow.
And it's frustrating, So what you do is you try to take really good notes of everything that you review, because you can't charge the client to look at it twice.
Yep.
But anyway, what we find with these new Dalbert challenges, Robson does a great job. And I just shortened Robson Forensic to Robson. Robson does a really good job training all of our experts and constantly monitoring them. And now that we're seeing these Dalbert challenges, we're finding that because Robson tends to be a little higher quality of expert that some of the other firms might be, what they do is they can't undermine us on our opinions. So they come after, they attack us, our background. They try to go after, that Rule 702 and say, you didn't do this part of it. But one of my jobs and one of the jobs of all the peer reviewers at Robson is to go through every opinion offered in every report and make sure it adheres to Rule 702.
I'm curious, is there a big difference between being an expert witness and an experienced structural engineer? Like, are there experienced structural engineers that also be expert witnesses in trials, or is it mostly companies like Robson that provide those services?
Because of these more recent Dalbert challenges that we see more and more often, the answer to your question is yes. An experienced structural engineer in general can hold himself out to be an expert in a field. The difference is we bring in people who are experts in their field. In our case, we're talking about structural engineers. So we hire experienced structural engineers. The difference is at Robson, we train them how to be an expert, how to integrate that structural knowledge with the legal field. What to say, how to say it, what not to say, how to keep yourself out of trouble in depositions and reports, things like that. So these people who are just experienced structural engineers who hold themselves out to be experts, although that's true, a lot of them get in trouble because they don't know all of these legal consequences to their actions.
I think I would be very bad at the legal side. I tend to start sentences with, I think,
Right.
I imagine they don't want to know what you think. They want to know what the fact is, and that's... My internet cut out for a second, and we had a little blip, and then I said, standard of care. I'm curious to set the definition of that. Like, what does the standard of care kind of mean? And this can apply to many things. So, like, how do you set the standard?
Yeah, believe it or not, you get asked that as an expert in almost every deposition, because you often say your opinions are often of the form XYZ violated this applicable standard of care in a manner to have been causative. That's a very common, finding. Technically, the standard of care, design professionals must exercise the ordinary skill and care of a reasonably prudent member of their profession, practicing under similar circumstances in the same or similar locality. Now, with the advent of the internet, and like for myself, I have a national practice, right? I practice throughout the United States. I think I'm registered in 26 or 27 states. That same or similar locality is kind of questionable. basically what would a reasonable or prudent engineer do in this matter is basically the litmus test for standard of care.
Gosh, I feel like that would be very hard to define. And, many general structural notes, the firm that I work for has the same, that this structure has been designed based on the standard practice in the area, which is kind of it is a general statement, right? But it is the intent of the design that it should follow what the general practice is in this area. And I don't know, I think defining things that aren't math it's hard for me.
No, great point. And you're right. It's vague, right? It's
Yeah.
not like math where 1 + 1 is always 2. What the real litmus test, what it comes down to, reasonably prudent, right? That's a little easier to understand. Was any applicable, because there's all kinds of standards, was any applicable standard, which includes the code, which are requirements, violated in a manner to have been a cause?
Is there any instance that is just always the case that something fell below the standard of care, that it's very easy to swipe this, like this is clearly not what the engineers of the industry should be seeing?
Sure. There's often, and I know you're probably going to ask me for example.
Yep.
Let me try to think of that one. But very often, let's see. Okay, I had a case where it was a big event where a lot of people were invited. It was a rodeo. The event venue contracted with a scaffold erector to erect scaffolds in the form of a U so that people would walk underneath them as they entered into the venue.
Mhm.
As a way of funneling the people. But what they did is they decided to put vinyl signs all over the scaffold. So now we've got a sale, right?
Yep.
Oh, yeah.
Fortunately, somebody realized it's a sale. So we're going to need, in their mind, we're going to need to brace this thing. So they took pipe scaffolding, attached it in a very non-specific way to the scaffold, and anchored in a non-specific way to those parking barriers, right? The Jersey barriers.
Yeah.
Well, for a layperson, you look at it and you think, okay, should be okay. Well, a relatively foreseeable wind event, meaning like less than 30 miles an hour, came, interacted with that scaffold, that incorrect, improper, insufficient way of bracing it failed. It fell over and struck 3 people and they were injured, right? So there was an engineer who worked for the scaffold company. He chose not to design it. He said it was based on something he had seen somebody do 8 years ago, and they just set it up, right? And they asked the venue, do you want to pay for engineering? And they said no. So in this matter, they deferred to a decision of a non-professional where they were in a position to know better, right? That's a violation of a standard of care.
Okay.
The engineer and the scaffold people know better than the venue about engineering and what's required. They had an engineer, he didn't design it. That's a violation of a standard of care.
That is a very interesting one because, in a contract sense, it's very different, but you'll often say, like, would you like me to do this little portion as well? And you think of it as, it's just a little bit more engineering. I can't think of a good example of this, but you'll say, well, it's not in the contract. We're not doing that. It's not in our responsibility. But if it's part of the building operating correctly, that is within the standard of care. And I should think about that more. I don't know. I didn't have my head on yet. Structural defers a ton of stuff because although you and I, might be structural, things are definitely outside of our typical scope occasionally. So maybe we could do them, but they're engineers that are pros at this, and we say using them will save the project money and make a better final product. Stairs, railings, connections if you're an East Coaster, canopies, trusses, curtain walls, precast panels, the list is huge. So Mark answers this appropriately, but I just wanted to say, if your mind is still asleep as well, we defer to a different structural engineer on most projects.
Well, I think you do, and you haven't thought about it in the context of this conversation. For example, you design a building and you require that all the shoring be designed by a professional licensed engineer,
Yes.
and you ask for that shoring as a shop drawing to review. right? So you've delegated that to a specialty engineer. You've chosen not to do that design, but you've ensured that is done properly. So you've done the right thing. You've met the standard of care.
I could see a tough scenario where if your building is so hard to construct, but your general structural notes probably say something like the erection of this building is fully in the house of the contractor or whatnot, and they can hire an engineer if needed. If you're giving them something that is so hard to construct, there is a blurry line of, was this possible that an engineer could manage, or did you give them something that is not happening?
Sure. So the topic you're talking about, the issue is constructability, right?
Yeah.
Some engineers put out sets of plans that may be more constructible than others. It's not a violation. It's the same thing. You know, one guy says this needs to be steel. The other engineer says, no, concrete's better.
Yeah.
Right. Neither one of them are wrong. A less constructible version of a set of plans isn't necessarily wrong. They may not come back to you for a second project, but methods and means, we all put this note, number one, almost in first note, method and means of construction is the responsibility of the contractor, right? If he wants to hire an engineer to help him with methods and means. Okay, here's another case. Big forming company. They do high rises. Big forming company. They're on the 30-something floor of this large building. They're putting forms up for an exterior walkway kind of theme up at the top at the roof. Overnight, a big wind event occurs, big storm event comes, blows off some of the plywood forms, some of the horizontal plywood forms, and they fall to the ground. And unfortunately, a gentleman who was riding his bike gets struck in the head by one of these forms who have just fallen from 30-something feet, and he's killed, right? So the contractor actually gets sued, even though his subcontractor, the forming company, was the one who was responsible for this. And they were responsible because although they designed it for all the vertical loads, they didn't design it for wind loads.
Yeah.
Wow. How often, and I don't even know if this is like in cases, are you finding that it's like just human error? Someone woke up tired and probably just missed it versus like actual negligence of like, I just not going to do my job at all.
Yeah.
Is that like a thing?
Well, absolutely. Both of them are a thing. So most cases are what we call the perfect storm. 5 or 6 or more different things slightly went wrong. The culmination of all those things going wrong led to a problem. But I did a case where a firm designed the hopper, the triangular part at the bottom of a grain bin, to discharge the grain. And I'm literally reviewing his calculations. And he's going through, and the hopper design consisted of a bunch of triangular shaped steel plates that were screwed together, right? So I'm going through his design, and he's checking space. He gets down to where he's checking spacing of screws, and then he just skips edge distance. And his calcs are dated, right? So the next calculation is the next day, where he starts on a different subject. Yep. So he missed the edge distance, and it was an edge distance failure. So it seemed like he either left that day and forgot to come back to it, or he left for lunch. I don't know.
Yeah.
But one more step and he would have been okay.
Man. Yeah. I'm always so curious, or, in my career, when even just running into things in the field where something was slightly missed or something, it's usually that, just it was that next calc or just being human, right? I often think it's one of the hardest things of what we do is we wake up every day, and most of us, I think, try our best, but you may just be tired one day or, just miss something.
And you're right, Zach. We're not required, this standard of care, we're not required to be perfect. The law acknowledges that we are human and we will make mistakes. You can't sue us for a mistake if it didn't violate a standard of care. Just because you did a math error, that doesn't mean you violated a standard of care. Now,
I really like that.
if it's a public project where you have to have peer review and the peer reviewer also missed it, now that's something else, right?
Mm,
Now we've got two people missing, the same thing, and that's different.
yeah. Well, I want to start like stepping back a little bit and going through a new case and what that looks like on your end. So when you guys get hired for a new project or new case, where do you start?
Once we receive the engagement letter and our retainer, a phone call is made because we have an initial discussion with the attorney to find out about the case, to make sure that we're the right person to help them out. They're comfortable with us. Then we move forward with the contract and the retainer. Once we receive acknowledgement that we have a signed engagement and a retainer, you reach back out to that same attorney client in general and say, okay, we're all good. Where do you want to start? So mostly what they do in most cases, they send us discovery material, which we're typically not hired way in the beginning of lawsuits. They wait for a while, typically, although that's not always the case. Um, so they've got at least the complaint, which tells us there's a lot of factual information in a complaint. So we get good at reading legal documents. Oftentimes we will get deposition transcripts. We may get an OSHA report if there was a death or something like that, and it was during construction. We'll get contracts of the parties, and we'll talk about who are the intended defendants that we are going to be looking at in this case. So as you're looking through this new material, you're making notes and you're thinking about how these answers, sometimes they have interrogatories in the legal field where they just ask questions, or there's affidavits. So we're getting a picture of what happened. We review photographs. We may go to the site, do an inspection. We may have been brought into the case 3 or 4 years after the incident. So a site inspection would be, meaningless. Um, Even with that, sometimes the attorneys want us to do a site inspection just for the optics, just to say, we looked at the site, we understand all the conditions going on, how this occurred, where it occurred, that kind of thing. And it's just a transition from reviewing the documents, getting an idea in our head of what occurred, how it occurred, who was involved in it, and then it's like taking a pyramid and starting with the wide end and going to the point where you're able to distill your analysis enough to come up with 4 or 5 findings of your opinion. And that's, for us, in a report, 99% of the time we write reports, Pennsylvania, and then we'll be deposed and then possibly go to trial. There are different states like Pennsylvania where you're not deposed. You write a report, you go straight to trial. So it's different in different states, but it's a distillation of all the material that they've put together. In some cases, we get in a little early and we'll say, hey, would you like us to give you suggested questions for this defendant when you depose them? They love that because we'll give them questions we want to hear the answers to. So that
I
works
wanted
really well.
I wanted to ask if you could define two things that you brought up there: depositions and discovery. What are those?
Sure. Discovery is the first part of it. Discovery is the process in a litigation where they are fact finding. They are going out, asking questions, asking for affidavits, asking for reports, asking for photographs, asking for eyewitness accounts. They're getting all this information about what happened about this incident. That's all. Discovery is everything involved in the case materially. Deposition is it's a fact-finding mission by the attorneys. So if I write a report, the attorney on the other side will ask for my deposition. They will ask me to be deposed. They will take my deposition. They are trying to push me on my findings, see how well I support them. If I cave, if I'm nervous, if I can't speak well, if I'm stuttering, if I'm sweating during the deposition, they're going to love to take me to trial because they want the jury to see that.
Yeah.
If I speak well, if I'm confident, if I support my opinions, immediately, they're going to think twice about it. They're going to be more prompted to settle the case. And the better my report is, the more solid I would be anyway.
That
Is there ever a moment where the attorney's asking you the case is a good one? Is there ever that opinion from you where you're like, I went through it, seems like it's solid. I don't know if there's a case or anything like that?
Yeah. And that's actually a very, very good question, because one of the most important things we can do. So obviously our clients are attorneys. One of the most important thing. Now, let me first put a predicate down here. Plaintiffs' attorneys and defense attorneys, there's two different strategies. Plaintiffs' attorneys, you've seen those Morgan & Morgan commercials. I'm just calling that out. I don't know what the local plaintiffs' attorneys are in your area. You probably see their advertisements on TV too. All the plaintiffs' attorneys will tell you, you don't pay a dime until we win.
yes.
They're all like that, right? That's because they fund the case. They only take the case if they think they're going to win. They're not going to take a loser of a case. Defense attorneys typically work for insurance companies, so they're paid salary. They'll try the case till the end. So if you've got either one of those attorneys and you get some discovery material enough to come to an opinion, and your opinion is this is not a good case for my client, that's called a negative opinion. And one of the best things we can do is go to an attorney with a negative opinion early. So they know either to shut it down, don't spend any more money on it, or in the case of defense attorneys, they'll often still, they may not put us on the stand as an expert, but they'll keep us around as a consulting expert. We're not disclosed, but we're in the background telling them, you should say this. They said this, you should say that. So we help them out. We help them mitigate the damages, make it a little less. Plaintiff's attorney, they're usually really happy when they get a negative opinion early. So they know it's a bad case for them. They're not going to win. There's no way. They don't need to spend any more money. Some cases, some of the plaintiff's attorneys get pissed at us, and I don't understand that, but that happens.
I love the complexity of this. It's just things I've never thought about. So you had discussed this a little bit, but just to back on the scientific method, the process for a structural investigation, what does that really look like? And also, how long does that typically take? I'm curious on the time frame of these.
The length of time, again, great question. The length of time varies on the complexity of the matter. So I talked earlier about reliability and repeatability. Your analysis has to be reliable based on sufficient facts and data, and it has to be repeatable. Theoretically, any other structural engineer who goes through the same process with the same data will arrive at your same findings. And that's when you've got what I'll say are good experts on either side, you'll agree on the facts. It's just what to do. In fact, I had one case where me and the other side were so agreeable on the facts, the two attorneys threw us in a room and told us to decide how this should be determined, the outcome.
Yes.
And they actually took our recommendation. But back to your question, in a quick summary, the scientific method is create a hypothesis, test your hypothesis. If your test confirm your hypothesis, distill it to an opinion. Now, I'm using that in the context of forensic engineering. So if I have a case and I need to determine causation, something failed, I'm going to say in my head, I think that fastener failed. So I'm going to go through and test my hypothesis, and I could do that mathematically. I can say, like the grain bin hopper, did it have the proper edge distance? No, it didn't. And oh, by the way, it sheared. there was a shear failure because of a minimum edge distance adherence issue. So we test our hypothesis. If the hypothesis proves us right, we're able to support our opinion. You have to have support. And the way to do it is through the scientific method. If you don't support your opinion, which many structural experts do not do, there's a picture of a spall. And they'll say, oh, the concrete guy was responsible for the spall. Well, where's your support for that? Right. And by the way, that's a spall from a pneumatic, pin that somebody shot and later took out. So I say you failed to support it properly. Therefore, that's unsupported speculation. And like you said earlier, Max, I think this might be that's unsupported speculation. That's the last thing an expert wants to be accused of doing.
I live in unsupported speculation.
Right. Right.
So is that where you're trying to separate the root cause from the contributing factors, like trying to put all of that together?
Yeah. And a lot of times our attorney clients, they use the word proximate instead of root. They want to know what is the proximate cause. We push back because in almost every case, especially in those cases like I described before, where it's a culmination of 5 or 6 things that have gone wrong, there are an infinite number of contributing causes, including the fact that the parties got up in the morning and went to work. That's contributing. But was it contributing in a manner that it violated a standard of care? Was it contributing by violating a manner of care of a standard of care in a manner that was causative to the issue is what you have to get at. What we try to allow our attorney clients to state is that this was a contributing cause. This was causal to it. In the instances where our clients are adamant that they want us to use the word proximate, we say, okay, fine. Give us the definition for the word proximate in your state, and we will include it. And if we believe that to be true, we will say it under those ground rules.
I can't believe that the definition can be defined differently per state. In the same way that we say in our general notes that this has been performed by the standard care of the area, a lot of built-in, logical layers.
That's true.
Yeah.
That's true.
My question for you, though, so is there a type of structural case that you see most often or a causation of a failure? Is there any repeated things that you've seen in the industry?
We tend at Robson in the structural group to see 2 types of cases that we see quite often. One is a guardrail failure, whether it be a guardrail during construction, a temporary guardrail, or a guardrail on a balcony that somebody didn't maintain, or there's a myriad of other reasons why it might have failed. And then the other one is a failed wood deck. We see a lot of those 2 types of cases.
Interesting. Okay.
Huh. I know, yeah, in wood decks or decks in particular, it seems like the code has increased the live loads on those. So hopefully you see less of that. But it seems
it's actually not even about that, Zach. It's almost always because somebody failed to maintain them. I mean, wood you have to maintain.
Yeah.
If you have wood on the exterior and you don't maintain it, it's going to fail at some point.
And the onus of that is always on the owner, whether they're per se educated in structural engineering or not.
Yeah, here's the thing. That's right. The onus is on them, period. If they so they should, as a homeowner, I'm a homeowner, I'm responsible. I had a set of stairs. I bought a house 2 years ago. It had a set of exterior stairs and a wood deck that were falling apart on my property. Now I live on a lake. I've got kids that come around and fish. If one of those kids came on my deck and were injured, even though they may have been trespassing, it's still on me, right? So owners need to understand they are required to maintain their property, period. If they don't feel comfortable doing it themselves, they need to hire somebody that they are comfortable with. Now they have transferred that responsibility. So if they properly hired somebody that they could reasonably rely on, a structural engineer, a certified home inspector, all those people they could reasonably rely on, then in a lawsuit, they could say, I reasonably relied on that entity because I wasn't confident in my ability to do so. That's okay.
Is often their argument is that they just didn't know that it was in
Oh, yeah,
bad
of
shape.
course. Of course. Or, of course I did inspections. I was out there 3 years ago and I kind of looked it over and pushed and pulled on the guardrail.
Yeah.
Yeah.
We get a lot of that.
Is there a number on this time frame? Like, of course, I was out here 3 years ago, or is it what will happen in that time? Like, it'd be hard to put a defined, you must inspect your porch every 6 months, but in the standard of care perspective, like, if you're not out there just putting a number on it, right, is like, if you're not out there every season, then you're not using the space and you're not holding it to the standard of care of a usable exterior porch.
Yeah, that's a huge issue in all of these cases. So our position, and I think most experts' position in these matters would be the owner is responsible to properly maintain.
Yeah.
To properly maintain, they have to perform proper inspections. So then the question is, how often do they have to inspect, right? What is the standard of care? Google, when you get a chance, how often should I inspect my wood deck? And you're going to find 20 at least white papers on it and it's usually comes down to about 6 months.
Okay.
So you've got a consensus among all these people, whether it be home inspectors. One of the standards that we use is means, MEANS. A lot of people use them for cost estimating. They put together documents for the insurance companies. And one of the things they do is they put together for the insurance companies how often things should be inspected to properly maintain them.
And I assume there's
So
big
there
reach
are
in art.
applicable standards in the world, and we point to those.
Yeah.
And if I can find them with a Google search, so would a homeowner.
Gosh. Yeah, it was like a regional side, like a deck in Maine versus a deck in Arizona, see entirely different environments, and the inspection needs to correlate to that, I would imagine. So a lot of things.
Right. And then you got to take into consideration that we all know wood degrades.
Yeah.
Right.
Besides all the things we had just talked about, I'm wondering, can a design still meet code, but still be a professional liability issue? Like, can we do the design correctly from the desk side, right? Can we design a one-story building, but still have liability issues if generally it seems okay? But I know there's so many levels, like the screw edge that you had already mentioned is, if you didn't forget something, can you still have liability issues?
Technically, no. If you follow all applicable standards, make an attempt to follow all applicable standards, make an attempt to follow the minimum requirements of the code, then technically you shouldn't. Again, if you just flat out, when you're punching numbers, you press the wrong number and got a wrong answer, so you got 2 screws instead of 20 or something like that.
Yeah.
I mean, if it's an order of magnitude, you should have known better, right? That kind of thing. But if you put in 4 and you should have had 5 or 6, between you and I, that's not gonna end up in a failure because of factors of safety and things like that. But technically, no, you shouldn't have an issue with violating a standard of care. And that's part of one of the things that I recommend that structural engineers do is know these standards, know the ANSI standards, know the ACI standards, know the ASTM standards, know them. You say those things on your plans, but do you know what they really mean?
Yeah. In that respect, what technical skills matter the most in forensic work? Is it the code, the physics behind this so well? Or, I've thought about this is like, is it breadth of education or a very specific, if you're the best at one thing, does that help? Or being pretty good at a wide range of things, does that help in the forensic field, right? Because you are seeing lots of things.
You can be the best in the world at one thing, but you're only going to see those cases. If you're really good, but not the best at a bunch of things, you're going to see be able to do a bunch of more cases. But what's important, I think there's two things. One is, like I said, learning the standards. But the other big thing is never get complacent with the small things, like shop drawing review, calc review. The devil's in the details. I mean, remember the Hyatt Regency collapse? Do you guys know how that happened? Right? They changed the threaded rods in the shop drawing process. So where a lot of these companies, these consulting companies, they'll put junior engineers on shop drawing review instead of the engineer who designed it. I've never been an advocate for that. When I was engineering manager, I would insist, if you designed it, you review the shop drawings. If these companies who do that, they need to impart upon the junior engineers who are reviewing these shop drawings to make sure they understand their own company's drawings before they review them or as they review them. You know, those things are easily missed. And if you make a habit of not being complacent with the small things, you're not going to make as many mistakes and you're going to be a better forensic engineer too.
Getting into forensics, in my mind, and you kind of mentioned this too, is a lot of report writing and reading legal language. How important is it that you're really good at writing, communication, even public speaking to get into forensic engineering?
Unfortunately for us as structural engineers, those things are very important. So I remember English 101, the English professor was joking about the engineering majors who had to take his course. And he made a comment, something to the effect of, "I are an engineer." And I'm like, okay, I see where this is going.
Yeah.
And I don't know why, but I somehow learned how to write pretty decently. And when I started here, writing is super important here. Every case requires a report. Our reports are relatively formulaic. They're like a recipe as far as the outline of it, how it flows. Yeah, for 2 years, you go through, well, you never stop having a peer review of your reports, but for 2 years, you're getting back more red than black. You know, it's horrible. It's a hard process. You've got to have a really thick skin to be able to not let it get you down and learn how to write forensically. Speaking is the same thing, going into depositions, learning how to talk to an attorney, learning how to turn and talk to a jury. These are skills you have to learn. Public speaking, sure, nobody likes to do that at first, you know, but we have to, a lot of these events where attorneys go to get their CEUs, we will sponsor those as a marketing effort, and we're asked to give speeches there. Engineers, especially structural engineers, we're not cut out for that, you know. It's hard, you know, but if you know your stuff, it's easier.
Yeah.
That's true.
I'd say that's why most of us went into engineering, is to not write and just communicate probably.
I mean, what's the joke? You know, how do you know one engineer is more outgoing than the other? Because he looks at his shoes instead of his own.
Yep. After all this time in the forensic field, is there anything that you see that normal practicing structural engineers should make sure of, should change in their practice? I know, you know, in this discussion, I'm thinking the shop drawing review, I'm thinking about this, is I need to make sure that I'm seeing these things. So things like that, is there anything that practicing structural engineers should change or make sure they're doing correctly in their practice to give the best result?
Just kind of a repetition of the ones that I've hit, in addition to shop drawing review, calculation checking. Don't get complacent on anything. Get out in the field as often as you can. And the word that I use, and it applies to my guys all of our experts, is be precise. Be precise in your language, be precise in your writing, be precise in your calculations, be precise in your details that you draw. Precision is a skill. It doesn't come naturally. We want to be precise, but to pull it off, you have to be aware. And precision keeps you out of trouble.
What do you think is the most misunderstood thing that you maybe even yourself learned from when you were a structural engineer and then coming into forensics? Or what do you hear other structural engineers more curious about or asking you questions about what you do?
They don't understand how easy it is to get in trouble. It sounds really easy. Hey, I'm an expert in structural engineering. Let me into that case. I'll help you out. And they can, but they don't know the legal, how to integrate what you know with the litigation team. And that's where new experts get in big trouble, is just thinking this is an easy transition. When I first came on to Robson Forensic, which was, like I said, almost 16 years ago, they had a 4-year program where you were considered a newbie for 4 years.
Wow.
And there was tons of training. Robson does a super great job of training new experts to get them up to speed as fast as possible. Cost-wise, it's a great idea to do that. Otherwise, you're paying salaries and you're not getting a lot back in return. So it's that transition of taking your acquired skills over a long time and applying them to a new discipline and learning how that integrates. And I see people just thinking it's going to be seamless. I will have no problem. The people who do this on their own fail miserably fast. They get Dalberted out, they're done. You get Dalberted out, no other attorney's going to hire you.
Yeah.
Because that's on your record, and attorneys track these things.
Oh, that makes it scarier.
Yeah.
Zach, go for it.
Yeah, I was going to say it's probably intimidating because I'm thinking, as a 10 to 15 year engineer, you're fairly confident in what you've been doing as you've been practicing for quite a bit of time. You've probably seen things. And then to move into, truly a new career, as you're saying, like you're coming in to learn fully new skills, and just to think to go back into training things and just be wrong constantly for many years. I could see that being intimidating or challenging for many. Structural.
It's tough on your pride. You come from being pretty much top of your game to low man on the totem pole.
Yeah. In those first few years,
and being reminded over and over, you're the low man on the totem pole. It's part of the training process. It's brutal, but it's intended to get you up to speed fast.
Yeah. In the first few years, do you help build the case essentially? So you are doing the research. If you are leading this case, Mark, would the person that is helping you their first year in this, they're helping build this case? So doing the research, looking at, inspection, or is that also tied to the person, just keep using these words incorrectly, but like that is in court, like, did you inspect it and you have to say, yes, I inspected this, or was the team?
So I think I understood your question.
Yeah,
I'm going to answer it. If I don't, let me know.
Yeah.
So I have a relatively new expert in my group. He's 2 years, with Robson. From the time now, 2 years to the time when he first came on, once he's in a case, it's his case. He checks in with me very often. We have talks daily, more then than now. Everything I get to everything needs to be reviewed. No opinions leave Robson Forensic without a peer review, and that doesn't matter if you've been here 20 years or you've been here a year. They have to be peer reviewed. And if you give a negative opinion, 2 peer reviewers have to agree on that. So it's your case. You will be deposed. You will write the report. You will go to trial. We will peer review all of your opinions. We will peer review your report. We will prep you for deposition. We will prep you for trial. But it's you from day one.
Perfect.
Did that answer your question?
It does. Yeah. I was just thinking, like, how does this start? And that is exactly.
You're jumped right in. It's you, and you better know which questions to ask and which things to bring up to your peer reviewer, because if you miss a couple, The worst thing in the world is to be jumped in a deposition by the opposing attorney that you made a mistake.
Yeah.
It's a horrible feeling.
Are there
That's
clearly
all the question.
easier cases when you start, like, in your first year? I keep thinking of this as, is there, when a case comes into Robson, can you say this one will be cleaner or less complicated or not to extend for 2 years? Like, do you have a good feel for when the case comes in the door, what this might look like? Not like if you win or
100%.
not, but okay.
100%. Yeah. Yeah. The fact patterns are very clear and very obvious. And after you do it a couple years, you can see that. One of the first trial I ever went to was a case about stacked bags of rice. Okay.
Yes.
So they were 50-pound bags of rice that a supermarket just stacked. Now, the interesting thing was they stacked it like almost 10 feet, right? So what they did is they buttressed it by adjacent stacks. So the problem is, so you have 4 or 5 different level, all kind of in like a pillar, right?
Mm.
But they're all buttressing the other one. They all kind of lean on each other. But these people are trying to get 50-pound bags of rice into their shopping cart. And some lady maneuvers, you go to the lowest one. You have to. Eventually, you remove the buttressing and all the stacks come over. And that's what happened in this case. But this woman, when she did that, she was hit with 400 or 500 pounds of rice. It was huge, you
Yeah.
know?
Wow.
So what did they violate a standard of care? Sure. They understood that they had to buttress it. They couldn't have just one tall stack, but they didn't go back and maintain the stack so that it wouldn't be unstable.
How unique.
I lost. I think my side lost. A lot of
Oh.
times you don't find out,
Yeah.
but it was my first case. It was crazy.
How many cases would you say that you guys work on go to court versus kind of settle outside of court, if that's even the right question?
No, it's a great question. The structural group, the cases usually settle more often than, let's say, some of the other groups like the architectural expert group. Almost all of those go to trial. Those guys seem to be in trial 3 times a month.
Wow.
I've been here, like I said, almost 16 years, and I think I've been to trial less than 20 times.
Okay.
I've been deposed maybe 50 or 60 times.
Interesting.
So a lot of the construction deviation cases get settled after a report, especially if you write a good report.
Yeah.
Yeah.
How many cases are you seeing on average? Like, in 1 year, about 12 cases or?
I think the better way to answer that is most of the civil engineers carry somewhere between 40 and 60 open cases.
Yes.
Wow.
It's a lot.
Yeah.
Yeah.
And then you get attorneys who, some of them are really great. They'll let you know you have a report due this time. So these are case management orders set down by the court, and it's dictated. Your report is due this time, depositions are due at this time, trial is this time. And those often change, and they keep you abreast of all the changes. Some of them are great. Many of them, and these are the ones that are challenging for us to work with, we're already on 40 or 60 cases. We're already pretty busy. Then you get a phone call from one of those clients. Hey, how's it going? Did you know that your report's due in 4 days? No, I didn't. And guess what? You're going to have to ask the court for an extension because there's no way I can get that done. And it really upsets them.
Yeah.
But-
yeah.
So, yeah, we've talked a lot about the standard of care from a structural standpoint. I would imagine in my head is, doing structural engineering on a daily basis, that often the mistakes are made in the field more often than maybe in the calculations, or maybe that's where they become more prevalent. There's an equal understanding of standard of care from construction defects standpoint too?
Oh, absolutely. Sure.
Okay.
One of the biggest ones we see is concrete cover,
Mm.
right? Not enough concrete cover in the field. Was it the guy who placed the rebar? Was it the inspector who checked it? Was it the general contractor who's supposed to be checking his placement? Was it the concrete guy who actually placed the concrete and moved the rebar? You know, did the other side, a lot of times the other side doesn't acknowledge and include the tolerances allowed by ACI for placement.
Yeah.
They'll say there were 300 instances of out of tolerance concrete cover that were observed. Well, if I take into account the tolerances by ACI, there might have been 7. Right? So now we've got a different looking case. It's not 300 violations, it's 7.
Yeah.
Big difference. That's more easily settled.
Yeah, I didn't even think about that too. It's not only just the math, but then the tolerances on the construction side for each material.
We know this is a unique field. It also has a few unique legal requirements that go with it. After our call, Mark realized this case wasn't closed. I pulled a few minutes out from the conversation right here. What comes next?
Is there ever a case that comes across something that's just a wild, I don't know. I think from a practicing standpoint, there's things that, different firms do, the nonlinear or performance-based type design. Are there cases that come in ever that you're like, that's kind of beyond what we feel comfortable with? Or is it always we can bring it back to basic math, physics, and first principles, so we can always kind of help solve these or provide guidance?
Yeah, it's more the latter. And that's usually what it comes down to. If it gets so complex that it needs to be, a battle of the finite element analysis, that's probably not one we're going to want to get into.
Yeah.
We'll let the Thornton Tomasettis and the Wish Janeys of the world, have those battles. We're gonna get all the other ones where it's not that level of complexity. It's just our business model. That's all.
Yeah, no, that makes complete sense. Well, is there any questions that we have not asked that you think would be important for our listeners to be aware of?
If you want to get into forensic engineering, try to get out in the field more. Try to understand the standards. Try to understand all these. Read the commentaries. The ASCE. The commentary is gold. It gives you such an insight of where these numbers come from. That insight helps you as a forensic engineer. Be aware of the fact that you are going to be a teacher, right? That's what we do. We teach our clients about what we know. If you talk to attorneys that do these types of cases, you'll find like post-tensioning, you'll find a couple of these attorneys know almost as much as you and I. They don't know how to do the math, but they understand it because we've taught them. Robson Forensic is looking, for structural engineers. If anybody out there is interested, it's a very rigorous selection process. We hire very few of applicants to ensure that we only take the best of the best and keep that going. But if you like this kind of work, structural engineering, you feel you're ready for a left turn to try something different, you think you have the right experience, we'd love to hear from you.
Well, fantastic. Mark, thank you so much for being on the podcast. I know I've learned a lot. I feel like we should in the future think about another episode together of just like talking through cases, because I think I could spend all day just hearing stories.
The
about
details that you can dive into here.
The stories are fun, aren't they? Yeah, I've had a great time. Thanks for having me.